Let's take a look at news now concerning Parliament's efforts to exercise its oversight powers. The Portfolio Committee on Public Enterprises is seeking alternative ways to summons the Guptas and Dudu Myeni. This is after, of course, they failed to reach them due to questions over their whereabouts. And the former SAA Chair, Dudu Myeni, also failing to appear before the committee. Now, what are the legal implications of all of this? In studio with me is legal expert Ulrich Roux. Ulrich, thanks for your time tonight. Let's perhaps quickly just begin with the separation of powers. When does the situation move from beyond Parliament being able to serve summons on somebody to actually it becoming a criminal matter?
Evening, Cassie. Yes, well, that is governed by legislation, and that is the Act, the Powers and Privileges of Parliament Act. Now, that Act states that any person, when called upon by Parliament to answer questions, must do so, and if that person refuses to answer those questions and cannot furnish proper reasons as to why they refuse to answer those questions, then Parliament can make use of any means at their disposal in order to enforce their rights and to bring that person before Parliament in order to answer those questions. So the function of Parliament being able to call people is governed by an act, and that act states quite clearly that they can use whatever means possible in order to bring that person before Parliament.
You're talking about that act and what it says, and part of it, as I was reading later, part of it also includes a sanction for the violation either by way of fine or imprisonment for a period not exceeding 12 months, or you could have both. So what are the options that are available to the Speaker now?
Well, she can make an application to the Hawks in order for a warrant of arrest to be issued for these people in order to bring them before Parliament. So it's a very serious sanction. You know, I think what's important to note is that since 1994 and the promulgation of this act, it has never been necessary for a warrant of arrest to be issued to bring anyone before Parliament to answer questions. So in other words, these are the first individuals who have bluntly refused to come before Parliament in order to answer questions. So certainly a new precedent will be created if a warrant of arrest is issued for these people.
But it's step 2 from my understanding of the process, Ulrich, because, and of course, how it relates to Dudu Myeni and Dudu Myeni and the other family Gupta members are different, because there's the issuing of summons. So in the case of Dudu Myeni, the fact that these summons had been issued, I think they were left at her house, does that mean that she now falls within stage 2 of ignoring that summons? Can that be deduced from how she's responded?
Well, it's an objective decision that needs to be made, and it is similar to the decision that is made by a magistrate or a judge when a person is served with summons and they do not appear before court. An inquiry must be conducted as to why that person did not appear, firstly. Secondly, was it properly received by that person? Did they have knowledge of the summons? Were they aware that they needed to appear? And I think that the Parliamentary Committee could prove beyond a reasonable doubt that Dudu Myeni definitely knew that she needed to appear before the Parliamentary Committee. So I think that as you call it, step 1 has been completed. You know, it's now gone on to step 2 or phase 2, and that is that Parliament must now do whatever they can and use whatever means possible in order to ensure that she is now brought before Parliament. And once again, if that necessitates the issuing of a warrant of arrest, then so be it, because the Act states that they can use whatever means possible in order to ensure that that person does attend to Parliament to answer the questions.
What applies to Dudu Myeni and the Guptas, given the issue of their whereabouts, which until today nobody has been really able to answer with absolute clarity?
Well, once again, the same process will have to be followed. You know, were they properly served with these summons? Were they aware of the fact that they needed to attend to the parliamentary hearing and inquiry?
But perhaps before you continue, what constitutes a proper serving of summons, especially where the individual involved cannot be traced?
Well, then they must be made aware of the fact that the summons has been issued. It can be served in other means. In terms of our Criminal Procedure Act and our civil procedure followed in courts, if a person cannot be served personally, then it can be served on another person who accepts service. That person must be above the age of 16, must be sound and of sober senses when they receive the summons, and thus they can pass on this message of the summons having been served on them to the person who it is intended for. So once again, if it necessitates the fact that it is served on the attorneys of these individuals or via a third party, but that summons is accepted on behalf of the third party, then that constitutes proper summons. You know, if the person is then not available or out of the country or whatever the case is with these individuals, then the next step must be followed, and that is to possibly approach the South African Police Services, possibly get Interpol involved, and possibly serve it on people and try and enforce that summons in a different jurisdiction. Although now you're going into a different field, and that is that they could possibly have to be extradited in order to attend to these hearings, which I think is very unlikely, unfortunately, for the hearings, but of course in a criminal matter that could become more likely.
So you bring me to my next question then. When it comes to the criminality, when does this issue of ignoring Parliament take on now the criminal sense, where it is followed up through the police exclusively? Not necessarily exclusively, but where the police now must also be held accountable for the whereabouts or being the inability to trace these individuals.
Yes, yes. As I said, it is governed by the Powers and Privileges of Parliament Act, and that has a criminal sanction to it. So if this person ignores it or they simply refuse, then a hearing will be held by a criminal court and by a magistrate or a judge in order to determine whether there's sound reasons furnished as to why they missed this hearing and why they simply just ignored it. And that is where the criminality comes into play. But as I said, the Act is clear in that any means possible may be used to bring these people before Parliament, and if that necessitates a warrant of arrest, then so be it. And once again, it'll be the first time since 1994 that these steps would have had to have been taken in order to ensure that a person does indeed appear before Parliament.
All right, well, we'll wait and see exactly what the Speaker decides to do in this particular matter. It would certainly be very interesting if it got as far as having to include Interpol and having to extradite people. One wonders whether or not there is will, at least political will, to see it through to that extent. Lawyer Ulrich Roux giving us a breakdown of the legalities around how the process of serving the summons on those who are needed in Parliament but have been absconding, really, the Eskom inquiry. What can be done to bring them to book?